So I'm Jennifer O'Neill. I have a very loud microphone, holy smokes. So I'm an elder law attorney, so I practice in the area of estate planning and elder law. And a couple comments about what Dr. Severson was just talking about. So another great way to store your power of attorney for healthcare is have pictures on your phone. Or if your kids have phones that will use pictures like iPhones, just have them snap pictures of the power of attorney on their phone so that they have it available. And kids these days, they can do a lot of things. Or I'll scan it in so they have a PDF available. And we really do tell people in our office to have copies and put them in their suitcase or in their purse when they're traveling. And so the example I use is, your husband, because it's always the guys that fall down and hit their head, right? So your husband falls down and hits his head while you're on vacation, and you have to take him into the emergency room. And you can say, yes, I'm his wife. And that has a certain amount of power and authority and credibility, but then if you can pull out that power of attorney and say, I'm also his healthcare agent, that really helps. So all the things she said are really accurate, but there was a question about where to get the forms. And there are lots of free forms available online. You absolutely do not have to use an attorney to do a power of attorney for healthcare. And my absolute favorite is from a nonprofit called Honoring Choices. So with an H, I don't know if you can understand me with the microphone and the mask, but Honoring Choices, and you would just Google Honoring Choices Wisconsin, because powers of attorney are created by state law. We didn't have powers of attorney until mid to late 70s, and so they're created state law. So Minnesota documents are different than Wisconsin documents and all over the country. So you want to be specific about the state where you are. Was there a question? Oh, sorry. So Honoring Choices Wisconsin, and what will pop up first as an organization that has a PDF that you can print off is Aurora Health Systems. There's nothing fancy about Aurora Health Systems, it's just that they start with the letter A, so they come up first. So print those off, and they're really user-friendly forms. And from a lawyer's perspective, the reason you want the Wisconsin forms, and the important part of the Wisconsin forms for estate planning attorneys, elder law attorneys, is there's a section that you check a box to give your agent authority to admit you to a nursing home, or it's called a community-based residential facility, a CBRF, which is how we license. That's the licensing title for assisted living. Mark the yes. It does not mean you want to go to a nursing home. Nobody wants to go to a nursing home. That's nobody's goal. But what it does is it allows your agent to admit you if you are not competent to admit yourself. And so what happens in Wisconsin, remember Dr. Severson said that Wisconsin has a lot of patient protection rules? That's one of them. And so in Wisconsin, to be admitted to a nursing home, even for rehab, be admitted, you either have to be competent to admit yourself. If you're not competent, maybe because you've had surgery, you have a lot of medication on board, you have a UTI, there's lots of things that could cause you to be short-term incompetent. But if you're not competent to admit yourself, what?
We're getting muffled. Do you want to just take your mask off?
Sure.
Maybe, and you can keep the mic a little farther away.
Okay, how's that?
Better.
See my media coach here. Well, there, now I wish I had lipstick on. So back to the nursing home. So if you're not competent to admit yourself, you have to have a power of attorney for healthcare, giving your agent specific authority to admit you. And if you don't have that, so if you've marked those boxes no, because I never want to go to a nursing home, doesn't mean you don't have to go. It just means they don't have authority to admit you. So then we have to do a guardianship. The only other way the nursing home can let you in the door is to have a guardianship on file. And guardianship is not a terrible thing. Sometimes it's very necessary, but you're already having a health crisis. Your family is already spending a lot of time and energy and maybe financial resources on the health emergency. The last thing they need is to deal with a lawyer. Not that we're not always delightful, but it would just be so much easier to expedite that. So that's the value of powers of attorney for healthcare. So Honoring Choices is my favorite because they have good instructions and they're very user-friendly. The second is the Department of Health Services. Wisconsin Department of Health Services has free documents available on their website that you can just download, and those are going to be a little less user-friendly, a little more legalese-full. What would be the term for that? But it's still a good document. And when you go online, and Dr. Severson was using the terms a little bit interchangeably, and that's part of the confusion with advanced directives, is living wills are different than powers of attorney for healthcare. Living wills are very limited documents that just express your desires if you're in a persistent vegetative state or in a terminal condition. So do you want, I think it's life-sustaining treatment, do you want tube feeding? But they're basically a page long. What powers of attorney do is powers of attorney share your legal authority with somebody else. So they go that extra step to say, if I can't make these decisions, here's this person that I trust who can, examine the circumstances and make a decision based on what they think I would want. So living wills, sometimes folks don't have somebody they can name as an agent, and living wills are better than nothing. But by far and away, powers of attorney for healthcare are much more valuable in the long run. So there. I was just dying to explain all that to you guys. So now we'll start my hour presentation. Haha. I'm kidding. I'll try to wrap it up in about 20 minutes. So we're going to talk real quick about estate planning. And before we even kind of get into all the exciting parts, I want to do the basic stuff. So your estate. Wait, one more part. Something that Dr. Severson, something that Mike O'Connell usually steals from me. Mortality is 100%, right? Right. Yeah, so I should ask Dr. Severson that. But I'm very respectful. I really, really like Dr. Severson. Are we going to object to that?
No.
Okay.
I can back you up a little bit about power of attorney.
Okay.
Touch a little more on durable power of attorney. The
Oh.
importance of that.
Okay.
Just power of attorney.
Okay, so I will. So what I wasn't sure where you were going with that. So what he mentioned is he wants me to just explain the difference between just a standard power of attorney and what we call a durable power of attorney. A durable power of attorney is a power of attorney that you sign while you're competent, but it continues in effect if you become incapacitated. So when you think about a power of attorney for healthcare, a power of attorney for healthcare is always going to be durable because it doesn't even go into effect. Your agent doesn't even have any authority until you become incapacitated. So where we really see the difference with durable power of attorney is there is also a power of attorney for property and finance that gives somebody else the authority to handle all of your personal business. Those can either go into effect right away when you sign them, so they're in effect, your agent has authority while you have capacity, or they can be what we call a springing power of attorney. Your agent doesn't have any authority until after you become incapacitated. That's what healthcare powers really are. They're really springing powers of attorney. But durable powers of attorney for finance will continue in effect even after you become incapacitated. And it just kind of stands to reason that the purpose most people, the purpose that we execute a power of attorney for is so that somebody has authority to manage finances if you cannot. So durable simply means that it continues in effect if the person signing it, the principal, becomes incapacitated. Is that what you were thinking? Yeah, I very rarely see non-durable powers of attorney. They're out there and they have, valid uses, but in estate planning, we're almost always doing durable powers.
And upon death, the power of attorney or durable power of attorney terminates.
Yep,
Done.
yep. Did you hear that? Powers of attorney, so the way that I explain them, they're, bye guys. Now, they aren't being rude. They were here this morning. So they came back to say hello and have cookies. So powers of attorney, share your legal authority with somebody else. When you die, your legal authority ends. And so does the legal authority of your agent. And that's really kind of tricky. I've talked to bankers that don't understand that. I've talked to people in the financial world that, aren't quite sure about when powers of attorney actually terminate. And your agent's authority terminates when you revoke it or when you die. Anything else?
And in the effect of that, like, I've got an elderly mother,
Uh-huh.
and I'm durable power. So then you need someone to take care of the estate is called what? I can't think of it.
Personal representative.
Yes.
See, now I'm just going to go sit down and eat cookies and you can do the rest.
I'm just trying to clarify some of this for me.
I'm happy to do that because you know what? This is what I do all the time. And so what I think is clear might not be what the rest of you think is clear. So I really appreciate you bringing that up because that's how, somebody out in the real world sees it. So speak up. Speak up. Any questions so far? We all remember the part about everybody's going to die, right? Mortality is 100%. So everybody's going to die, and then estate planning. So what's your estate? Your estate is everything that you own on the date of your death. There might be a lot of items and assets in your estate. There might be just a few. But every time somebody dies, we have an estate that we have to deal with somehow. And when I talk about dealing with an estate, I usually wiggle 5 fingers. Everybody see my 5 wiggling fingers? So I wiggle 5 fingers because every time somebody dies, we have to go through what I call administration. We have to administer the estate, and there are 5 steps. So the first step is to identify the heirs and beneficiaries. Who do you want to get your estate? Who do you want to get your assets? Second step is to identify the assets. And we could talk an hour about how to organize information, but identify assets. Third, identify debt, because even if people don't have a car payment or a mortgage or something, almost everybody has a last little phone bill or electric bill or funeral bill or something. So identify debt. Fourth step, use the assets to pay the debts. And the last thing we do is we distribute the remaining assets back to those heirs and beneficiaries. We do that one way or another every time somebody dies. And I call that administration. And there are 2 paths that we can use to get through administration. The traditional path, the long-standing process that we have had historically in the state of Wisconsin and every other state, honestly, is probate. So probate right now gets a really bad rap. But what probate really is court-supervised administration. In the court, it doesn't mean that you have to go, to the courtroom and talk to the judge and, take questions and be examined or anything. It's not that intimidating. What I really mean by court-supervised is that the court is involved and the court is reviewing the work that's being performed for the administration. And the way that the court reviews everything is the person who's in charge of the probate administration, the court appoints somebody called a personal representative. And in movies and TV, they're always called the executor. But in Wisconsin and Minnesota, we call them the personal representative, and they're appointed by the court. And the personal representative's job is to get through administration. And the way that the court supervises the personal representative's work is the personal rep has to file paperwork. They have to file the right paperwork with the right information in the right order. And that's what the court reviews, and it's not the judge, in Wisconsin we call them the Register of Probate. And the Register in Probate or the Deputy Register in Probate will review everything, and if they think there's a mistake or you missed something, they'll let you know. And once everything is completed and all the paperwork has been filed, the probate administration closes. So it's a long-standing, really well-structured process. And all of the paperwork is available online. I don't even know if you could go to the Register and Probate's office and pick up a paper packet. We used to be able to. I started practicing in '94, and we would have to go sometimes pick up copies of the paperwork before we had the internet, guys. So probate is our traditional process for getting through administration. But remember I said it's gotten a really bad reputation? Part of the reason it's gotten a bad reputation is there's a lot of marketing of companies that want to do trusts, and so they kind of advertise against probate. But the other issues that are making probate less desirable, one, it's public. So even though, we put pictures of our lunch on Facebook and we, expose our lives online, in some ways we've become even more private about our assets, and probate is a public process. It's a public court process. Another thing is because it works so well, every time dying gets a little more complex, the legislature adds, kind of one more little step to probate. So it's gotten more complex, and people don't appreciate that. And it has become a little more confusing because we used to be able to have more independent work. That's not really the right way to explain it, but you used to be able to draft a lot of your own paperwork, and so sometimes families would just kind of write out letters and questions to the court. Now everything is standardized, and so you have to use the correct form. Even lawyers have to use the correct form. And so in ways they've tried to make it easier, and they've actually made it a little harder.
And more expensive.
Potentially more expensive, yeah, because oftentimes just to jump through the hoops that they've created, you end up hiring a lawyer, and lawyers get paid. So anyway, probate. Probate is court supervised administration, and there are in total 4 options for estate planning. Remember, your estate is everything that you own. The planning part is just figuring out where you want your assets to go and how you want them to get there. So our 2 probate options are, 1, do nothing. Every single one of us sitting here, even if we don't have a will, trust, anything else, we all have at least one estate plan, courtesy of the laws of the state of Wisconsin. And it's called the Rules of Intestate Succession. Intestate means you died without a will. And we have this set of rules because so much of the time, historically, people died without a will. And so the state has an interest in moving these administrations along. So we have this set of laws that do basically one thing. They identify the heirs and beneficiaries. And so the Rules of Intestate Succession in Wisconsin, it doesn't give everything to the state of Wisconsin. It doesn't give everything, to the local judge. It actually directs the estate to your family, very much like most of my clients direct their estate. So in Wisconsin, if you die without a will, your first heir, your primary heir, is your spouse. Now there are little different rules if you have children outside the marriage, but otherwise your primary heir is your spouse. If you don't have a spouse, either because you're never married, divorced, predeceased, it goes equally to your children. If any of your children are deceased, it goes to their children, your grandchildren. So if you don't have spouse, children, grandchildren, it goes back up to your parents. If either one of your parents are alive, they would be your heir. If both of them are alive, they would share that. If both your parents are deceased, it goes out to your siblings equally. If any of your siblings are predeceased, to their children, nieces, nephews. It goes out like that for 3 generations. So I have been involved in probate administrations where the heir was, I think they were like a second cousin once removed, and they inherited the estate. And so, people worry about not having a will, not having an estate plan because they're afraid everything will go to the state. The only way that would happen is if you don't have any kind of plan and you don't have any relatives within those 3 generations, then your estate under Wisconsin law would do something called escheat. It would escheat to the state of Wisconsin. I have never, ever heard of an estate escheating to the state of Wisconsin. So in testate succession, we've got this set of laws that we have to apply to a set of assets, and so you're always going to need probate for that. You're always going to need court supervision so that the court can make sure that the right people are getting the assets and that the administration goes smoothly. But if you're okay with that administration and you're okay with your family going through probate, and like I said, probate isn't terrible. I kind of like probate. I think it's fun, I hate to say, but it's just very, it's kind of like cleaning out and organizing a closet. Only the closet happens to be somebody's life's assets. And so it's actually very satisfying to help a family through that process. So if you don't mind that they'll go through probate, because you won't go through probate, you'll be dead, remember. So you won't have to do any of the paperwork. It's your survivors. And you like the the distribution, it's okay to do nothing. It's okay to just rely on the rules of intestate succession. I give you permission. It's okay. That's why those laws exist. So everybody, congratulations, you have at least one plan. Now what if you don't like the distribution that we get under the rules of intestate succession? It doesn't include charities, it doesn't include churches, it gives everything equally to kids. What if you have one of your kids that you really, don't like that much? Kids don't always turn out the way we hope that they do, and I have actually been lucky enough to have some families in my practice that, one of the kids is just extremely successful, and they tell their parents, I don't want anything. I'm good. Give all of my share to my siblings. And so maybe we don't want everything to go equally to the kids, just for very wonderful reasons. The way to overcome intestate succession, the first option is a will. Now, I have all kinds of people calling my office and saying, I need a will, or I want a will. And when I hear that, what I really think is they need an estate plan, because a will is just one option for estate planning. And wills aren't as magical as a lot of people think they are. One thing is that wills do not avoid probate. Wills actually require probate to be put into effect. But there are many, many people who believe that because they have a will, their estate will not go through probate, and it's actually the opposite. The other thing to understand about wills and kind of the limits of wills is wills only really do one thing. Wills identify the heirs and beneficiaries. They identify who's supposed to get your assets. And they can direct specific assets to specific people, but their real job is to identify the heirs and beneficiaries. Now, the last thing that a will does is it allows the testator, the person signing the will, to nominate that personal representative. They aren't appointing the personal representative to do the work. They're just nominating that person, saying, court, this is who I want to do this work. This is who I trust. This is who I think is capable of doing that work. And if the court agrees and the person is able and willing, the court will appoint that personal representative named in the will. But that's all that wills do. Wills still require probate to be put into effect. Any questions so far? Is this fascinating stuff? I think it is. If anybody should think it's fascinating, it should be me, right? So what if, yeah?
How often do people that have been appointed as the executor say, I don't want to appoint anything to do?
So the question is, how many times that people have been nominated as the personal rep say, I don't want to do it? Very seldom. Yep, really, very seldom. Couple of different reasons. One, often when somebody is, creating their will, they check with the person that they're nominating to make sure that they're willing and able. Second reason, excuse me, I don't think it's COVID, I think it's allergies and talking all week. But the other reason is when you are nominated as a personal representative, you feel honored. You feel honored for about 10 minutes after you are appointed, and then it becomes work. And we could have a whole conversation about PR fees on that. So very few people actually decline to serve. More often when people decline to serve, it's because we've run into some kind of complexity, local rules that would require extra steps, and we just want to simplify it. So it's not as onerous as you'd think. So, you ready to talk? Quick question. Yeah.
If your personal representative is in a state, lives in a state other than Wisconsin, do they have to post a bond?
So speaking of complications, so the question is, if your PR, your personal representative, lives outside the state of Wisconsin, do they have to post a bond? In St. Croix County, yes. There is a local rule in St. Croix County that if your personal representative is not a Wisconsin resident, they have to post a bond. And so the reason why is probate is a state court process. It's not a federal court process, so the court only has jurisdiction within the state of Wisconsin. So you could nominate, or you could have a Minnesota, personal rep appointed. They could steal all the money and stand on the other side of the river and go, ha ha ha, you can't do anything to me. And legally, you can't. And so St. Croix County requires a bond, which is an insurance policy that compensates the beneficiaries if the personal representative misbehaves or goofs up. But in Pierce County, just to the south of us, I just learned in the last few months that they've implemented a local rule that I was not aware of. That if you have an out-of-state personal representative, the court in Pierce County will not appoint them. And I can't remember how I stumbled upon that, but I actually called the Register and Probate and I said, are you kidding? Do you really enforce this? And they said, yeah. I'm like, what are you guys doing? And they said, if you have an out-of-state personal rep, we require that you either, appoint an attorney or a professional PR. Now we'll see how long that lasts, but holy smokes. So it's these local rules that get in the way. So on to avoiding probate, because probate is controlled by state law, and that's not always the most wonderful, the most efficient process. So one reason that avoiding probate is so popular is because it's become really, really easy. And the reason it has become easy is tied to probate assets. So probate only controls probate assets. Probate assets are assets, the definition, assets that are in your own name on the date of your death, with no joint owner and no named beneficiary. So think about that. No named beneficiary. Think about bank accounts. It seems like every time a client goes in to set up a new bank account, the delightful personal banker asks them, do you want to put a POD beneficiary on that? And then clients come in and meet with me and they say, well, we just set up this new account and the bank asked me if I wanted to do that. And my first thought is, thank you, bank, for practicing law. But it raises the issue of, hey, what do we want to happen to this account when we die? So every time you add a joint owner to an asset, and I don't recommend running out and naming a whole bunch of joint owners to your assets, but spouses and significant others, it makes a lot of sense, and it's very, very common, especially in Wisconsin, for houses, cars, bank accounts, non-retirement investment accounts, for married couples and committed couples to own those as joint owners. And so when the first joint owner dies, their interest just kind of goes poof, and the surviving joint owner continues to own the asset without any probate. But what if you don't have, maybe it's a retirement account that can't be owned jointly? Or what if you don't want, your ultimate heirs to own the asset jointly, because that's an actual ownership. There are risks involved in joint ownership. That's where we turn to beneficiary designations. So think about life insurance. We've had beneficiary designations around for a long time because life insurance is traditionally controlled with a beneficiary designation. Well, these days, not only do we use beneficiary designations for life insurance, we can add beneficiaries to real estate, we can add them to bank accounts, investment accounts, retirement accounts. The modern way that we save, last 45 years, the way that we save for retirement is with IRAs, 401ks that have beneficiary designations. There are very few assets in Wisconsin that cannot be controlled by a beneficiary designation, and the main one, the common one, is vehicles. You cannot add a beneficiary designation to a vehicle. But when you think about how beneficiary designations work, I always say when the owner's heart stops beating, the beneficiary owns the asset. It's very quick. It's instantaneous. Now, there's still paperwork. That beneficiary has to wait for the death certificate, and then there's always documentation to either collect the life insurance, document the ownership of the real estate, take ownership of the investment account, but it's very, very quick and usually free, if not, inexpensive, if not free. So beneficiary designations, we've just developed more and more and more opportunities for using them, and eventually Wisconsin's going to allow beneficiary designations on cars. They've allowed it in Minnesota for 3 years, and so far I haven't heard any horrible stories about it, so it'll come to us eventually. So beneficiary designations are an estate planning tool. So when I talk about that banker saying, do you want to put a POD beneficiary on it? What they aren't explaining to clients is that if you want to change your mind, or if you want to redirect that asset, maybe to a different person or equally to your kids, you can't just put it in a will. You have to actually change the beneficiary designation itself, because beneficiary designations are incredibly powerful and they will be honored almost all of the time. And so that's particularly important for anybody who's had kind of change in their family dynamics, maybe a divorce. Any of you in a second marriage or a third marriage and you have retirement assets or old life insurance policies that you owned during prior marriages, go home and check your beneficiary designations, please, because you might be unpleasantly surprised about what beneficiary designations you forgot to change. And so I could tell stories about that. So beneficiary designations are really, really wonderful. But there are 3 circumstances where you have to be careful. One is minor beneficiaries, minors under the age of 18. Why? Because minors are incompetent to own and control assets. So if you leave an asset to a minor, what might need to happen is that minor's parent then has to go to court and be appointed the guardian so that the guardian can take control of the asset till the minor turns 18. So yeah, you've transferred the ownership quickly and easily, but you've created a complication on the back end. Second, individuals with disabilities, maybe under the age of 65, and this morning somebody said, be careful with elderly folks that are maybe in facilities or getting some kind of government benefits, either medical assistance or VA benefits. So people with disabilities often are on government benefits that we call means tested. So means tested refers to the requirement that the program recipient have limited assets or limited income. So you could leave, a small bank account to somebody who's on SSI, which is a Social Security disability program, and kick them off of all of their assets. And it can be very, very traumatic, very scary for the family because, these folks rely on those benefits for food, shelter, health care, everything, transportation. So be careful with beneficiaries who have disabilities. And the third group of beneficiaries to be really careful with, and notice I said third group of beneficiaries, it has nothing to do with the asset. It has nothing to do with you as the owner of the assets. It's always the beneficiaries we have to plan for. Be careful of large families or fighting families. I used to say large fighting families, and then I realized, wait a minute, it only takes 2 kids to fight. And those aren't considered large families. So fighting families, even if it's just 2 kids, or large families. And the reason I say fighting families is even bank accounts, the bank is going to wait until all of the beneficiaries submit their claim forms before they pay a dime. I learned this not really the hard way, but an interesting way. My dad died last summer, and it's just my brother and I, and he lives in North Carolina, and I love him to death, but he's the most unorganized procrastinator in the whole world. And so, me, the lawyer, got my paperwork in right away. And then my brother, it's like, come on, when are you going to get this done? Well, he wasn't doing it to be vindictive. He's just a procrastinator, and he's unorganized. So it took him about 3 weeks. But imagine if he was being vindictive. Because, siblings, we're really good at fighting. We have a lifetime of practice. So what if he wants to be vindictive? It's like, I'll show her. I'm not ever going to send that claim form in. And then what do you do? It's kind of like, then what do you do? You'd have to go to probate court, and you'd have to have a little fight, is what would have to happen. So be careful of fighting families. And then large families, especially with real estate, because you can add a beneficiary designation to your house. And as soon as your heart stops beating, your family owns the house. Now, they can all agree that, yep, we're going to sell the house, and we like this realtor, and we're going to list it for that amount, and we're going to accept this offer. Now, all of those are opportunities to fight, but then they all have to participate and sign off on the transaction. And so you're really hurting a lot of cats. And so the goal of beneficiary designations is to simplify the process, and in some circumstances, you're almost better off with probate than you are trying to wrangle all of these different parties to, keep the transaction proceeding. So when I talk about probate, I always say, it's a really well-structured dictatorship, because the personal representative has all of the decision-making power, and they can get all the work done. So if you have a personal rep who's really efficient and good with paperwork, probate can go really, really smoothly. So probate isn't always a terrible thing. Sometimes it's the lesser of 2 evils. So beneficiary designations, but in families where you have adult beneficiaries, usually adult children, and they're healthy and they get along, consider beneficiary designations. They're really wonderful. They're inexpensive, so they're cost effective. They're efficient after you die. I've had families that they get through that whole process in about 5 or 6 weeks. Again, because everybody gets along and they're good with paperwork and they're efficient. So yeah, question.
Well, how do you actually do
Mm-hmm.
Want to do it? Do you go to the clerk of court and say, I want to
Mm-mm. So the question is, how do you actually add beneficiary designations to assets? So bank accounts, you go to the bank and you'll just ask the teller or the personal banker, tell them that you want to add a POD, a payable on death beneficiary designation to your account. Beneficiary designations, there's two pieces of vocabulary, and it depends on the kind of asset. So POD, payable on death, are for those assets that we pay out, like bank accounts, not even, well, I think life insurance. Life insurance is technically a POD. The others are TOD, transfer on death. So real estate, we don't pay out real estate, we transfer real estate. IRAs and investment accounts, we don't pay those out, we transfer them out. So with investment accounts, you either deal with the company, so if you have an online account with E-Trade or something like that, but if you work with like an Edward Jones or a Raymond James or all that, you talk to your financial advisor. Real estate, you usually are going to work with an attorney because we use something called a designation of transfer on death beneficiary, a transfer on death deed. So it's very much like a deed that we draft to transfer ownership of real estate. It's just that you're not transferring ownership. And the reason I say you want to work with a lawyer for a transfer on death deed is because usually real estate has significant value, often it does, and with a transfer on death deed, if you do it and you do it incorrectly, it's going to fail, but we're not going to know until you're dead. And so with lawyers, you have a higher likelihood that they're going to do it properly, and if they don't, hopefully they're going to fix it when they find out there was a problem. So that's how you do beneficiary designations. And so I just want to really, really quickly talk about trusts, because everybody gets all excited when we talk about trusts. And trusts are, remember I said there's 4 estate planning options? Trusts are our second non-probate option. And there's lots of different kinds of trusts out there. I could talk about trusts, I swear, for 2 hours. I hope we don't, but I could. So whenever you think about a trust, and there are lots of different reasons that we use a trust, because trusts can do everything except fix you a sandwich. We use trust to avoid probate, we use trust for minor beneficiaries, we use trust for disabled beneficiaries, we use trust to manage assets over time, we use trust to avoid some estate taxes. Trusts can do just about anything. But every single trust at its most basic operates exactly the same way. And that, I always say, picture a basket. Like an Easter basket or a picnic basket with a handle. Are you with me? Kind of like, Yogi Bear and Boo Boo, they used to go around stealing picnic baskets. Picture a basket. The reason I say picture a basket is because every single trust is nothing more than a container to hold and control assets. That's it. So trusts are ideally created in writing, best created in writing, and they're private agreements among the parties to the trust. Private meaning you don't have to get approval from a court or a company. It's usually family members that are participating in a trust. And every single trust has at least three parties. There may be more, but every single trust has at least 3. The first party is the grantor. The grantor is the person who is creating the trust. It's the grantor's goals and priorities that we are addressing with the trust document. So the grantor gets to make all the decisions about how the trust is going to operate. And the reason the grantor gets to do that is because it's the grantor's assets that will go into the trust. Grantors never change. Once you become the grantor of a trust, you are the grantor forever, and we still call you the grantor even after you die. The second party in every single trust is the trustee. The trustee's job is to hold the handle to the basket. The trustee owns and controls the assets in the trust, but they do not own and control the assets with their individual identity. They own it and control the assets as the trustee, which means they can't do whatever they want. They can only do what the trust document authorizes and directs them to do. So the trustee does have limitations, and there are controls. They have what's called a fiduciary duty that the court takes very, very seriously. So trustees are very often people. Sometimes the grantors are actually the first trustees. So trustees change over time. What's one reason why? Mortality is 100%. If you're the trustee and you die, it's hard to sign paperwork, right? You make a rotten trustee. So trustees, one of the decisions that the grantor makes when we create the trust is, if this person can't be trustee, who should come next? If they can't be trustee, who should come next? And that transition can be very, very smooth. So trustees are the second party. Third party in every single trust is the beneficiary. The beneficiary is the one who gets the goodies out of the basket. So they might get to eat the apple pie and the sandwiches or the chocolate bunnies, or they might get the money, they might get the income, they might get the assets that are in the trust. And just like trustees, beneficiaries usually change over time because we have the primary beneficiary, who is very often the grantor. And then when the grantor dies, they no longer need anything from the trust, so then we have the next beneficiaries. So, often it's parents are the grantors and the primary trustees, primary beneficiaries, and then they grow older. They might turn the management of the basket over to one of the kids, so they can kick up their heels and not worry about that stuff anymore. And then they eventually die, and that child can continue as trustee, but then perhaps the children or the grandchildren become beneficiaries. And so we use trust to avoid probate primarily because we're removing ownership from the grantor, and we always have that trustee that has the legal authority, and they have the direction in the document to administer the assets in the trust after the grantor dies. And there's a question back there.
For the trustees of a trust, does it work the same as a PR if they're outside Wisconsin? Do they still need to post a bond?
No, that's a great question. So if you didn't hear the question, do trustees, if they're outside the state of Wisconsin, do they need to be bonded? No, because trusts are private documents. They are not, there are elements of state law, but they are not specifically controlled by state law and not controlled by state court unless you bring them into court. So no, you can set your own conditions for trustees. The other thing about trusts is because they aren't going through probate, they're private. Our perfect example, Prince. Do you guys know who Prince is? He's a I don't know, rock and roll singer? He's Prince. Needs no more explanation. But anyway, he died a few years ago, and the reason that we all know about everything is because he didn't have a will. He didn't have a trust. So his whole estate is going through probate over in Minnesota. It's public record. So that's why we hear about it. If Prince had had a trust, we wouldn't have nearly the information about it that we do now. So if you want to maintain privacy, trusts are a great way to do it. Beneficiary designations are a great way to do it too, because if you set up a beneficiary with a bank, and one of your kids calls the bank, says, hey, my mom has an account there. Am I the beneficiary? The bank isn't going to tell them. And that's why I recommend getting your beneficiary designations in writing now, but that's another discussion. So any questions about estate planning? I mean, truthfully, I could go on and on and on and on, but we'll all get tired and hungry. So one last question.
How much is that bond in St. Clair County?
So how much is a bond? It's going to depend on the value of the estate, because it's an insurance policy, so if it's a large estate, the bond is going to be more expensive. And it also depends on the insurability of the personal representative. So some people are not bondable. They either don't have their own personal assets, or they have, criminal records or financial problems, and an insurance company will not bond them. Then we have to look to a different PR. So, I would say $1,000 to $4,000. It's not a few hundred, but it's not tens of thousands, but potentially several $1,000s depending on different factors. So, one last question, and then we'll get Cassandra up here.
In regards to beneficiaries with trusts,
Mm-hmm.
let's say there's two children.
Yeah.
Named, and before you said, and if one of them passes,
Mm-hmm.
their interest that they were named, even though they passed away,
Yeah.
go to their children and on, or not?
So with beneficiary designations or with trusts?
Well, both.
So the question is, if a named beneficiary dies, what happens to their interest? The classic legal answer is it depends. So in a trust document, it should be addressed. If this beneficiary dies, what happens to their interest? Sometimes it will lapse, which means if they aren't alive to get it, it goes away and it would be shared with somebody else. Very, very often, especially in families, we have it going to their children or their issue. Beneficiary designations, you have to read the fine print. Sometimes it will go back to the other pool of beneficiaries, sometimes it goes to issue.